Welcome back to Real Estate 101. Today we're going to continue our discussion on family law and talk a little bit about the court process. And I'm pleased to be joined once again by John Schuman of Devery Smith Frank LLP. John, welcome back to the show.
It's good to be here again.
Okay, John, so I want to start today's show and I want to ask you, when two spouses are getting separated, what do they need to do to be ready for court?
Well, the first thing they need to talk about or think about is whether they need to be in court at all. Court is useful for a very limited number of people. And it's only the really high conflict, the mentally ill, the substance abuse, the abusive couples that need to be in court. There are a whole lot of other options for resolving your matters. It's no longer the case that when you separate from your spouse, you have to serve them with a divorce petition and start suing them in court. No, there's a lot of options. You go to mediation, you can go to arbitration, you can do collaborative practice, you can try to work it out yourself. And all those options are much cheaper, much less stressful, much more friendly, much more easy for you to do yourself or to do with the help of someone else, and give you a lot more control over the process than court. So that's the first thing you need to think about. The second thing you need to be thinking about is, who am I going to get to help me with this process? Because court is still court, and it is not an easy thing to do on your own. There are lots of rules. There's this book called the Family Law Rules, and you are expected to know them when you're representing yourself or someone else in court. And there's also a whole lot of law in family law. So it's very difficult to do it on your own. It's a bit like if you're trying to, your roof is leaking, trying to fix your own roof. Yeah, you can do it, but there's a chance it might, you might fall through, or the rain may come pouring into your living room, and you don't want to be there. So, and you really don't want to be there if you're talking about your kids or your finances or your future, which is what you're talking about in family court. So that's why it's important to think about, how can I get some help? Whether I want to hire a lawyer to be in court for you, whether you want to just consult with a lawyer to keep, give you advice along the way, or whatever you think you can afford, but that's another important consideration.
Okay, so let's say you do, you go through the whole process and you decide that you're going to court. How do you begin the proceedings?
Well, you start a court proceeding, any proceeding, by doing what's called a pleading. And pleadings are the documents where you set out the very basic ideas of your case. What you want, and what the orders you want the court to make, basically, and why the court should order those things in general. And that's called an application in family court. But in family court, you don't just have an application, which has to be filled out correctly, and make sure you ask for the right orders and you have the right facts backing up the orders, otherwise you'll get thrown out. You also have to file, if you're dealing with kids, a document called a Form 35.1 affidavit, which is an affidavit about parenting. It basically asks about your kids, what their needs are, do they have any special needs, have you ever been involved with the police, have your kids ever been involved in the police, have there been any allegations of abuse, are there children's aid societies involved? The judges want to know the basic information before they start making orders about kids. And you cannot start a family court proceeding. No matter how big the emergency is, you cannot start a family court proceeding about kids unless you have a sworn 35.1 affidavit. The second thing you have to, or the third thing you may have to file, is a financial statement. If you're asking for any sort of money relief, so if you want support, if you want property division, if you want a court to freeze someone's assets, anything that has to do with anything about money, you have to file a financial statement. And there's two financial statements. One is just for support claims, and one is for support and everything else. And they have to be filled out completely, together with 3 years of tax returns and notices of assessment, and all that has to be filed with the court. If you don't have that together, the court will not take your application, and you cannot start a court proceeding. And if you have a case that involves kids and money matters, you have to have all 3 of those documents filed, and they all have to be done properly. The affidavit and the financial statement have to be sworn before a commissioner, and everything has to be signed by you and by a commissioner in some cases, and it all has to be filed in the right timelines, and it has to be typed, and there's other procedural rules, which is why people usually get lawyers to do it for them. But all that has to be done, and if you don't do it right, you get rejected and you don't get your court proceeding started, even if it's an emergency.
Okay, so once you've gone through this process of preparing the documentation, the application clearly has to be served after. What happens after the application is served?
Once the application is served, and you can't do that yourself, you have to get someone else to do it. It's one of those rules. You can't serve your own application. The person you're suing, who is usually your spouse, they have an opportunity to respond, and they file what's called an answer. And the answer is the companion to the application. It's where your spouse usually sets out what it is, well, their response to what you've said, what the orders they want the court to make, and the facts that they say that entitle them to those orders. And the same rules apply to them. If there's a kids issue, they have to file their 35.1 affidavit. If there's money issues, they have to file their financial statement. And they have to serve that on you. It's easier for them to serve it because they can fax it on you, and you have to serve them personally if the person doing the application. But they have to serve this, and they've got 30 days to do that. And once that's done, if they've raised any new issues that you didn't start off with, like let's say you only asked for custody and they asked for support, then you can file what's called a reply. And the reply, you've got 10 days to do that after they serve you, and that sets out your response to the new issues that they raised.
Okay, John, so when is the first time that both parties need to be in court?
So unless it's a real emergency, and by real emergency, I mean like a real emergency, like someone's running away with a kid, or their assets have to be frozen because someone's taking them away, or there's other like big real emergencies, like almost 911 type emergencies, then your first step is what's called mandatory information program. And that's an evening sort of classroom type situation where you and the other party go to learn about the family court process and the alternatives to court. And usually they tell you when there's stupid things you shouldn't do in court to give you some advice so you don't get off the wrong foot. If it's is an emergency, then your first step may be an emergency motion. But in order for judges to hear an emergency motion, you have to convince a judge that it really is an emergency. Because the usual first time you see a judge is not in a motion, it's usually at a case conference. And judges like that because case conferences, there isn't so much fighting and arguing as there is at motions. So the first time before a judge should be the case conference.
Okay, John, so what is case conference?
A case conference is your first appearance before a judge, and it's a less formal appearance. A lot of judges like to do them in chambers, which is like their office, and you sit around the judge's desk. Some judges do it in smaller courtrooms where you can sit around a table. A few judges do them in the regular courtroom, but even then, they like to have a more conversational atmosphere and have it more of like a mediation type thing or more of a direct discussion with the judge than your traditional court appearance. Because what the judge wants to do at those first appearances is try to calm parties down, tell them what the court's going to be like, what happens if they get off on the wrong foot and go the wrong way, what the big fights will be like. And then the judge tries to work on resolving a lot of the procedural issues, the easy issues to work through, like when people are going to provide disclosure, how the case is going to unfold, what the next steps should be. And the judge also tries to see if they can work out some of the easier issues at the case conference. So what happens, like what's the schedule going to be for the kids until the next time you're in court, if that's possible. And it's not a case where people are all uptight and you're like being questioned or cross-examined. No, it's more of a conversation, and the judge is a part of that conversation, the lawyers are part of that conversation, and sometimes the parties are part of that conversation, although judges realize that parties are really stressed their first time in court. But you shouldn't expect to see a lot of fireworks and a lot of screaming and yelling. It's a conversation type of place where things try to get resolved.
Okay, so let's say nothing gets resolved in this case conference and one of the parties needs an order for support or child custody, whatever it might be. What do they do?
They go to a motion, and a motion is a formal hearing. And if you're in Superior Court, motions are where the lawyers wear the silly robes with the white toes and the gowns and the whole thing. So, and judges wear their robe with their sash and motions, and it's a very formal process. When you argue a motion, it's a little like a trial in that the judge makes a decision, except in a motion, the judge is only making a temporary decision.
Right.
It happens until trial. And so the judge doesn't rely on people talking in court and being cross-examined, they rely on affidavits. And affidavits are evidence, like someone talking in court, but they're written. And they have to be written in a way that's very persuasive, because often judges decide what they're going to do before they even come into the courtroom, having read the affidavits.
Right.
Affidavits are sworn, so you have to go see someone to swear your affidavit, and you really need to write it in a way, or have your lawyer write it in a way, that is really convincing to a judge. Then when you show up to the motion, one lawyer makes their argument, and it's based on the facts and the law, and the judge hears the law and there's an argument about the law is. So if you're going to do this on your own, you have to know the law, which means you're going to have to spend some time in a law library and try to figure it out. And then the other side makes their pitch and the facts and the law. And sometimes there's a little bit of a back and forth. And then the judge asks, any questions the judge has. Then the judge makes a decision. And then the judge at the end of the day decides which one of those two people is going to pay the other lawyer for having had the motion.
The costs.
The costs.
Okay.
So one side ends up paying, the losing side ends up paying for the winner's lawyer.
Okay, so besides case conference, is there any other mandatory steps?
There are very few mandatory steps, but they are, after you have a case conference, your next mandatory step is a settlement conference, which is a lot like the case conference step. The judge is trying to settle the whole case. And sometimes they're scheduled for longer periods of time, and the judge tries to deal with the whole case. After that, if you're done the settlement conference, your next step is a trial management conference. And once you're at that stage, the judge assumes you're going to trial, and judges don't necessarily try to settle anymore. Trial management conferences are about the logistics of trial, like how do you know when your witnesses are going to show up? How many witnesses are you going to have? What documents are you going to rely on at trial? What other things do you have to file with them? You need to have wheelchair access for the trial. Do you have to have application for the trial? Does anyone need some sort of other book other than a Bible to swear or affirm on?
Right.
So it's very logistically in the trial. It's not about settling anymore. It's about having your trial. And then the last step is the trial, where you have, it looks like you see on TV, you have witnesses get into witness boxes and they give their evidence and they get cross-examined, and it goes on usually for several days for people to tell their story, and they get cross-examined, and then the judge makes a final decision. And the judge, based on what they've heard, decides what your life is going to look like from now on.
Okay, so how long do all these steps normally take from beginning to end?
The whole process takes usually a year to 2 years, although it can take much longer if the case is complicated or the parties are really fighting. You should assume that it'll take between 4 to 6 months between steps, because that's not only the amount of time the court has, because they have to schedule a lot of people in to have these steps, but also the amount of time you have to get other things done in your case.
And what happens between all these steps during this 4 to 6 month process?
Well, a lot happens. That's where the main part of the case happens. But what happens most critically is disclosure, which is where parties exchange their financial information about the children, everything they need to know. We don't have trial by ambush in Ontario, so you have to show all your documents to the other side. They have to show you all their documents which they're building their case.
You get to see what they have, they get to see what you have.
That's right. And that happens throughout the process. And as you do that exchange of disclosure, you get an idea of what their situation is and you know what your situation is. There's often a lot of negotiations. And so that's an important part that goes on, and you try to settle the case, because going the whole way is very, very, very expensive. So if you can settle it early, that's better. And if you can settle it even along the way, that's better than going the whole way. So there's often a lot of negotiations. Throughout the whole process too, you're also going to be preparing for trial, because trial is a very difficult, expensive thing to do. And when you start at the beginning, you should be thinking about who are the witnesses I'm going to have at trial and how do I make sure they show up? What are the documents I'm going to rely on? Because you need to collect them.
In the event you do go to trial.
That's right. And being ready to go to trial often helps settlement too, right? Because if you're the side who is like, I could win this trial, then the other side is going to be more willing to settle with you.
Right.
And so that's, and all that preparation and time, and meeting with your lawyers, maybe trying mediation or doing some other steps in the middle, that happens in between the 4 and 6 months in the middle. And it takes people a lot of time to do all this. So it doesn't actually, it may seem like a lot of time, but a lot of people are saying, I need more time to get this done.
Okay. So for today's final question, I want to ask you, is a trial always necessary?
Trials are very rarely necessary. And when you look at the number of cases, family law cases that actually get to trial, it's under 1%. And the reason it's under 1% is A, because it is extremely expensive to have one lawyer. Some people have 2 lawyers on all day, every day, not just while the trial, but also preparing for trial. So that's incredibly expensive. There's a lot of rules in court, and a lot of things that have to be served properly and bound properly and
followed by. And
yeah, they have the right color papers. They have to have tabs, which are shockingly expensive. So it's a very expensive process to report. So people, after they get into it a little while, want to get out of it as fast as they can and try to find a way to settle or go to mediation or arbitration to save costs. So very few cases go to trial. And the other thing is that, when you get all that disclosure in the middle and you get to know each other's case and things start to work out, it's a lot easier to negotiate a settlement, and that's where most cases end up. It's under 1% of people go to trial, and that's very fortunate because, as I said, it's a terrible process, not only because of the cost, but because you stand in a witness box and you tell the world how awful the other person was, and if it's a parent, you're talking about an awful parent they are. That's not the sort of thing you want to get back to your kids. So it's a case that almost everyone wants to avoid, including the judges who are trying to help you along the way.
All right, John, good stuff. Thanks for coming on today's show. It was another great topic, and I'm looking forward to seeing you again next month.
Thanks for having me. Family court, like all family law issues, can be really difficult, so if you need help, give me a call.
Thanks, John. So if you're going through some family law issues or you need some more help or just a little bit more information, check out some of John's other episodes on our website. Thanks for watching. I'm your host, Joe Trucera, and we'll see you next time.